Hello, my name is Thomas Hack, and I'm a partner at KPMG, and I focus on assisting clients on forensic accounting-related matters. My one big thing for Securities Enforcement Forum West 2020 is to be on the lookout for a large spike in stock drop securities matters, particularly related to COVID-19. We've already seen a handful of cases filed, one against a pharma company alleging that they had created a vaccine in March, another against a cruise line alleging they misled investors in their SEC filings. With earnings season upon us, this is likely to become a trending issue.
Welcome back. This next panel is right on the cutting edge: cryptocurrency regulation, enforcement, and litigation. I mean, no area of securities regulation has experienced such attention in the last 50 years probably as crypto. And the SEC Enforcement Division has been on a tear in its crypto-related enforcement efforts. So very excited about this panel, and there's just a lot that's unsettled or completely untested. And this panel is going to talk about all of that. So let me first introduce our moderator, Michael Dicke, who's a partner and also the co-chair of the blockchain practice at Fenwick and West. Of course, Mike was previously the Associate Regional Director for Enforcement in the SEC's San Francisco Regional Office. And he's quickly become a leader in private practice in navigating the mostly uncharted legal waters of cryptocurrency regulation. Welcome, Mike. I can't wait to hear you mix it up today with the SEC. I know they're winning a lot, but it will be interesting to hear what goes on today. Welcome.
Thanks, Bruce.
Let me introduce Steve Buchholz. For over 14 years, our next panelist has worked as a senior official in the SEC's Division of Enforcement in San Francisco. Steve has been a panelist at this conference many times, and he's the consummate SEC professional who can handle whatever topic or case he's presented with. He's now quite active in the SEC's exploding crypto enforcement. And Steve's here today to discuss the agency's current very successful approach. Welcome, Steve.
Thanks, Bruce.
I'd like to introduce Dr. Nicole Moran. She is a principal at Cornerstone Research who has made herself an essential element of any sort of cryptocurrency investigation. Her value proposition is special. She understands the economics, the pricing, and the inherent financial characteristics, easy for me to say, of transactions that have not only just come into existence, but are also continuously evolving. I always enjoy hearing from Nicole and getting her insights, and really thrilled she's here with us today. Welcome, Nicole. Thank you.
Thanks, Bruce. Happy to be here.
Finally, Kristen Smith is our last panelist on this crypto panel, and she's a real pioneer. We're lucky to have her here today. She runs the Blockchain Association in DC, where she leads the crypto industry's development of a strategic roadmap for public policy. This is no easy task. It requires a mastery of not only the legal intricacies of very complex technologies and concepts, but also the underlying policies. So welcome, Kristen. I can't wait to hear your perspective on the many crypto developments.
Looking forward to it.
Thank you all. Mike, let me turn it over to you.
Thanks again, Bruce. Well, let's get started. We've got an awesome panel. Of course, if you have questions, please send them in. Let's get started by asking each of you, what have been the most significant changes or developments in the digital asset space in terms of regulation, enforcement, and litigation since our panel last year at this time? Steve?
Thanks, Mike. And before I get started, I'll give the standard SEC disclaimer that the views I am expressing today are my own and do not necessarily reflect the views of the Commission or other members of the staff. Thank you for the opportunity to be here today. I would say we had a very busy year in the Commission and in the cyber unit, and I think we probably added about 15 cases in the crypto space to the series of cases that we've brought over the last few years, including 2 litigated Section 5 only registration cases that are probably the most significant in terms of developments. The case that was filed last June, and then the Telegram case that was filed in the fall. And in March, most people are probably familiar with the ruling that came down on the preliminary injunction motion and granting the preliminary injunction in Telegram. So obviously a very significant decision for the program, applying from our perspective, the Howey analysis, the way that we believe we've been applying it through this series of cases and the progression since we issued the first report, the Dow report back in 2017, that kind of it gave the industry notice that tokens could be considered securities in certain circumstances through a number of actions over the years. But the Telegram ruling, which obviously is on appeal, we believe it was correctly decided, and it was a significant development for us.
Thanks. Another development that hasn't seen really any enforcement cases, but been talked about a lot, is how the SEC is going to deal with stablecoins. You want to address, kind of how enforcement is looking at stablecoins and what some of the major issues are?
Sure. Yeah. Obviously, I'm limited in my ability to talk about anything that's not part of a public filing at this point. So I can't talk about any specific investigations. But suffice it to say that as stablecoins have grown in market cap and popularity, it's something we're very much aware of and looking at as they grow and potentially present systemic risks in terms of leverage, collateral, those types of things. But I will say that they're very different in their structure. And as with all matters in this space, it really is a very facts and circumstances specific analysis. And so the way that a particular coin is structured and offered, whether or not it has two different components, a governance component and a transactional component, how it was generated in the first instance, just many, many different factors that would result in a different analysis potentially. But it's definitely fair to say that it's an area we are looking at. Not going to try to predict anything about future cases, but I do think that anyone who has seen the growth in popularity of them would expect that it's an area that we're planning to look at. Obviously, we need to have jurisdiction first, as with everything in this space, stable coins, exchanges, market manipulation, all of it depends first on there being a security, so that we have jurisdiction. And so that's one of the reasons that the analysis in Telegram was such an important analysis and application of the security component. But I think going forward, we're certainly aware of some activities on the state level with regard to stable coins, as well as private litigation, to the extent that those also touch on the security analysis that's relevant to us as well.
One more follow-up before I move to the other panelists on this last point on stablecoins. So not that we don't all love having the SEC regulate our stablecoin projects, but for the stablecoin project, the rare one that doesn't want to run into an SEC enforcement action, I mean, what would be your advice in terms of trying to stay away from an SEC enforcement action?
Well, I will say that we have something called the Strategic Hub for Financial Innovation, FinHub, which is an attempt. It's a cross-divisional attempt that does offer real consultation. It's very prominent on our website, sec.gov. If you go to FinHub, it's a collection of actions and speeches and statements that have been put out on everything related to this space, as well as a way to initiate consultation and discussion about projects that are underway. Now, obviously, the agency is not in the business of giving advisory opinions on anything, but certainly we are genuinely interested in having a dialogue, and that is not an enforcement project. That is cross-divisional, and the real goal of that is to give a point of contact for folks who are working on legitimate projects, and there are many of them, to ask questions. Obviously, we encourage people to also work with counsel, experienced counsel in the securities laws, because there are a lot of technical areas that may apply. But we would encourage people to come early and initiate discussions, and as projects evolve, to continue having a dialogue. It certainly is not going to guarantee that there won't ever be an enforcement problem, but I think it is the best way that we have to encourage that dialogue. And we really, our goal is not to kill or stifle innovation. There are a lot of exciting opportunities in the blockchain space, and we want to encourage that as much as we can. It really is the issue of seeking investments from U.S. investors. That's always going to be the touchstone for us, that we will have to make sure that it's compliant with our securities laws. But in general, there is a process through FinHub, and I would encourage folks to use it.
Thanks, Steve. Kristen, awesome to have you here. It's the first time we've had them. This is the fourth year we've done this panel at Securities Forum West, and it's the first time we've had somebody from the industry on the panel. So thank you very much for participating. What would you say have been the most significant developments or changes in the last year in the digital asset space?
Yeah, well, real quickly, just so folks know, the Blockchain Association, we're based in DC, and we represent the cryptocurrency players in the industry. So a combination of crypto spot market exchanges, early stage investors, and also projects that are building blockchains or building applications on top of blockchains. So when I speak on behalf of that collection of companies, really, which are the kind of leading, most reputable companies in the space. I do agree with Steve on a couple of things. I do think that, but not everything. I do think that Kik and Telegram have been the most significant developments probably in the past year. And I know we're going to go into that later, so I'll save my thoughts on that. But one other thing that I do think was a significant development for the industry was, a little over a year ago when the additional guidance came out on how to apply the Howey test and the investment contract analysis to token projects. That was not the easiest guidance to sift through and figure out. But I really do think that the industry did step up, and that the exchanges and some of the other infrastructure players developed the Crypto Rating Council, which launched in September. And the significance of that is they took all of the guidance that the SEC gave through the Howey test, previous case law, and then also the principles that came out in April of 2019, and created a methodology for analyzing token projects that was based off of the SEC's own words. So and the good news is that the members that are all part of that organization, the member companies, are all using that same analysis that's repeatable. Now, this analysis is not endorsed by the SEC, but it is a really good faith effort for the industry to do something in sort of a uniform way. And then they can determine how close these different tokens might be to a security, and figure out their risk tolerance, and figure out whether to list or to custody or whatnot. So I do think that's actually been very significant, because it has provided a process that the industry can follow in order to make decisions about given token status.
Interesting. Thank you. Let me ask, follow up to Steve, if the SEC, I don't think the SEC's commented on the Crypto Ratings Council. Do you have any thoughts about it?
I don't think it's anything that we would take a particular view on. Obviously, in every case, we're going to look at the specific facts and circumstances. We're not going to rely on or agree with any private analysis. I mean, to the extent that people in the industry are working on coming up with, or just discussing a shared interpretation of the framework. We believe the framework is a helpful document, but I agree that it needs to be applied, and can be applied differently based on a lot of different factors. No one factor is determinative, as the framework says. So it's still, even if a group comes to a conclusion or a rating of some kind, there are a lot of different questions that can come from that in terms of where does it fall on the scale? What does that mean for what to do going forward? So, like I said before, I think we would encourage people to consult with experienced securities counsel. But the more discussion, the more sharing of information, that's certainly not a bad thing. And through the cases that we've brought, the best that we can from the enforcement division, we've tried to send a clear message that has progressed through the cases. And we believe it's been a consistent approach. And so I think it's a natural development and a good development that the industry is working on understanding and coming up with some common understandings.
Great. Kristen, you were on our panel last year. So what do you think are the most significant changes or developments?
You mean Nicole?
Yeah, I think you meant Nicole, but it's okay. It's okay. I knew. Yeah. So I think this year, what we're seeing a lot of is crypto-related projects are starting to have non-fraud related actions. And they're getting faced with both a government action investigation as well as private class action. And this is interesting because they're battling on two fronts, and it really changes the strategies and incentives for how they're going to deal with those particular investigations and be able to still continue on with their crypto project.
Can you follow up on that? And how do you think it changes the strategies for our project?
Yeah, so a lot of times we're helping clients with estimating potential damages and the risk for both the government investigation and the private class actions. And you have to do an equation and think about which one is going to be the most expensive or the most risky. And those are potentially the ones that they are trying to settle and then figure out where to battle after that. So part of the equation is how do we get through these investigations and come out on the other side and be able to continue on with crypto projects.
Yeah, I do think it's an interesting development. We're going to talk about the real rise in private litigation in a minute. But I noted that just this week there was a case filed against Kik, which we're going to talk about the SEC action against Kik. But there was a private action filed against Kik by a single plaintiff, not a class action, in San Mateo Superior Court, in state court. So I think that we're seeing a real evolution of this kind of dual-headed government and private litigation arising at the same time and posing some real challenges for projects to keep going as they decide the risks of from the government and the risks from private litigation. Well, let's talk about what's been identified as by several people as a major development in the last year, and that's the Telegram and the Kik SEC enforcement actions. Let's start with Telegram because we have an order ruling on a motion for preliminary injunction from the Southern District of New York. We have a ruling in that case after a lot of back and forth and fighting between Telegram and the SEC. So, Steve, let me ask you first. What do you think is significant about the Telegram decision?
I think there are several components of the decision that are important, but the entire analysis looking at what was an attempt to sort of break apart the offering into multiple components was looked at holistically and, with an eye to the economic realities of the project and the conclusion that it was one integrated offering, one distribution with the goal to ultimately get the tokens in the hands of the public. That is really the most significant. And then there are several components of that. I would say the analysis of the statutory underwriters and the group of initial purchasers, two different tranches of initial purchasers taking the tokens, but having a clear view to resale of the tokens, because that was a relatively limited group, I think around 175 purchasers, but with a clear view to ultimately making those tokens available on a much broader scale to the public through secondary platforms. And so the conclusion that was one offering really drives the analysis. And in terms of the private offering, public offering distinction, it's a significant decision from our perspective because of the way that the token economies have so often focused on getting the tokens out on secondary platforms and creating liquidity so that the initial purchasers can quickly sell them and make a profit. There are some details that are also really interesting in terms of the differences in the tranches. The first tranche having holding periods that anticipated, certain release points, but the second tranche having no holding periods, and that I think it's a significant element of the decision where it notes that essentially is creating an incentive for those tokens to be sold quickly to get out in the broader hands of the public to create a market. And so that is the analysis that we've done in a number of cases, looking at one offering, one distribution of the tokens, even if it starts with an argument that it comes within Reg D, one of the exemptions, if the goal is to have the tokens be distributed broadly to the public without an analysis or any reasonable steps to determine if they are accredited investors, that is likely going to cause problems. And so I think that analysis is very significant. There are references at several points in the decision as well to legal disclaimers not being controlling and sort of looking through what was really, I think, from our perspective, more of a form over substance attempt to create, narrower groupings, narrower parts to the offering, and finding that just wasn't sufficient to comply.
So I think what's throwing people at picking up on your last point, is that this is a project that had sophisticated counsel, sophisticated project, well thought out, and in the initial token issuance, it appeared that they hit all the elements you would want for a valid Reg D exemption. There was a waiting period, credited investors, and yet the SEC still found that initial token distribution was violated the registration provisions. And I think that's what I think a lot of people are trying to figure out how, first of all, whether that's good policy, because it does have an effect on other issuances under Reg D of equity. People are following all the steps, so they have to worry about an SEC action. And also in the token, the specialized token practice field, that people are saying, well, what do you have to do to actually do a valid issuance? How do you respond to that?
Well, I think that a lot of the problems come from the fact that the same token that's ultimately going to be distributed into the hands of the public is the means by which the expectation of profits is created for even the early purchasers, especially the early purchasers. And so it's that tie together that creates a problem. And so I don't disagree that it creates some significant problems in terms of the structure of using a token for multiple purposes that includes providing a reasonable expectation of profits to the initial investors in the project. In our view, if you look at the scheme, as a descriptive term, not as a pejorative term, But the series of understandings and agreements about the offering and the way that the tokens are going to be offered and ultimately come to rest in the hands of the public, if that involves tokens and a reasonable belief objectively that there's an opportunity to profit from that, that's, in our view, that's something that's going to come within the traditional scope of the investment contract analysis.
Kristen, I'm guessing you disagree with.
Got lots of thoughts.
Yes, and the association did put in an amicus brief in the Telegram case, right?
Yeah, we did too. We actually did one at the district court level and then one for the appeal at the Second Circuit. We also filed one in the KIC case, which I know we'll get to.
Okay. And then just to be clear, the appeal is from the entry of the preliminary injunction. So it's an appeal it's still just in the early stages.
Yes, that's correct.
Well, what did Steve get wrong? What did the SEC get wrong?
Well, listen, I mean, I think if you at the very macro level, I think what the SEC might be getting wrong here is that this does appear to be some sort of like new regulation or guidance that is being done through an enforcement action, as opposed to maybe an open rulemaking process where we actually make policy. Because I do think there are broader public policy questions that would be better answered through a rulemaking process or through a legislative process. So I understand the world that Steve has to work in, but I do want to kind of frame where the industry is coming from and the challenge that the industry has been working to address in order to work within the best guidance that we now have from the SEC. And you have to remember that cryptocurrency isn't just something people gamble with. It is fuel that is used within an open network. And this open network is distributed, at least in theory, some of them are up and running, but some of them are still in the idea phase, are these networks that are a different way of delivering digital services to businesses and users and consumers. And in many ways, these networks are better at delivering whatever this digital service be, where it's just a transfer of value or some sort of a financial service to different services that upgrade the web infrastructure. This is a new model that provides the option of more privacy, more competition, more security. So there's good reasons we want to build these networks. And the challenge is, in the beginning, it's an idea that only a few people have. And if in order to see that idea become a reality, you have to hire a team of developers and have this effort to get the code written and launch this project and this idea. And so in the early stages, that looks a lot like a company. And then what a typical company would do is go out and raise equity and build that project. And then the people who have equity would reap the benefits of what somebody owns. But because this group of developers in the crypto world are building something that's open source, nobody owns that at the end of the day. So there's this challenge of figuring out, how do you finance the development of a network that ultimately is going to belong to the public and isn't going to be owned or controlled by any single entity. And so the pre-sale of tokens in kind of the post-DAO report was the answer that crypto came up to. They said, okay, great, what we'll do, we'll sell to accredited investors only. We will not hand them the tokens right away, but promise to deliver them in the future at the time when the network is functional. And we will be able to use that money in order to build the network. And then at the end, when the network's functional, the investors who invested will have, if we succeed, we'll be able to take advantage of the network because they'll have tokens that they purchased at, perhaps a lower price. And so this was sort of the crypto industry's answer to doing this. And we've seen many projects across the board, including Telegram and KIC, that have used this sort of Reg D offering as a way to raise money on the front end. For these crypto projects to be successful, you have to have a secondary market because there's no single entity that can redistribute and circulate the tokens amongst the audience of people who would want to use them. So getting them to a secondary market is important. And what we've seen with both Kik and Telegram is tying the Reg D offering to either the future sale or distribution, or in the case of Telegram, that it hasn't even happened yet. So we don't actually know a crime's been committed because they haven't even gone to a secondary market. So it sends a signal to the crypto industry that this type of pre-sale offering is not, a way to distribute this. And it kind of is forcing the industry to go back to the drawing board and be like, well, how else can we get these tokens out there? And there are a lot of projects that are sort of midway of doing this, that have raised money, that are trying to figure out how to launch. It raises all sorts of questions for them, because this really was a good faith effort on industry participants to comply with securities laws by working only with accredited investors. And now there just isn't a pathway from getting to this early stage to a fully functioning network. And the ones that are out there, the projects that exist, the tokens that are out there, seem to have gotten the advantage of just being early before the SEC had time to get in there. So it's a very frustrating process that, isn't necessarily the enforcement division's fault, but I think really is a broader, we need our policymaking community to come in and try to find a pathway to get from this early stage to these fully functional distributed networks.
Perfect. Nicole, thoughts on Telegram?
Yes, I'll just keep it pretty short. They seem to be caught in this, catch-22, what's been called the regulatory catch-22, whereas I thought that they were taking the high road with the Reg D, and I was really surprised about the action. But then from an economic standpoint, then you think, okay, what are the incentives for other players? And like Kristen said, they have to change how they're thinking about incentives now. Do you just go ahead and launch your platform like block one and then ask for forgiveness later? Is that where the incentive then goes? So it just leaves a question about how to build a better mousetrap and how to get these platforms launched, because Telegram didn't even have a chance to have a dispute about whether their platform was decentralized enough. They didn't even get to the point to say, is it decentralized enough not to be a security? So they're sort of stuck on the starting block on that.
Interesting. Let me pick up on that decentralization point, because I think it's a central point in the Kik litigation. So Kik is a separate project, also an SEC enforcement action, and it's at the summary judgment stage. Right now, the briefing is, there's just some supplemental briefing within the last couple of days, but it is teed up for a summary judgment after a long discovery period, and will be kind of, I think, probably the next significant court ruling in this space. Nicole, how does decentralization play a role in thinking about the Kik litigation?
Yeah. So Kik is interesting because they did get off the starting block. Unlike Telegram, they have a network, and there's a lot of fighting and some pictures of honey badgers in some of the filings, which I always thought was quite cute. The honey badger is the honey badger enough to make this system up and running? So Kik has a system, and then they are claiming that is decentralized enough, and then the SEC is saying that it's not decentralized enough. And so why do we care about decentralization? This all comes back to the Hinman speech, where he says, okay, Ethereum is decentralized enough, and therefore it is not a security. And so immediately in my mind, I thought, okay, how do we measure decentralization? And so internally in Cornerstone, we went off and started collecting data, because that's what we do. We try to apply data to problems and trying to measure decentralization. And a lot of our projects have been comparing crypto blockchains to Ethereum, because we know we have a benchmark we can compare to now, which is Ethereum. And so we're counting the number of unique wallets. We're looking at how many nodes there are. We're looking at mining, where the mining entities are and how concentrated those are, comparing this all back to Ether and comparing this all back to Bitcoin, I've been trying to apply metrics to existing projects. And it's been extremely interesting because you can collect a lot of data and design different analyses to compare back and try to get a sense for, is your project decentralized enough to be able to not be a security?
I think we're going to see a lot more of that kind of analysis. I think it's important. And just to be clear, decentralization matters for one of the Howey factors, and that's the profits based upon the efforts of others. If you're so decentralized, then you're not dependent on a particular group's efforts to earn a profit. So that's a kind of a key part of the analysis. We're running a little short of time, so I'm going to move on to talk about private litigation. This is the year, I think, when we've all predicted there would be a lot of private litigation in this space. And there has been, litigation certainly over the last couple of years, but this year I think it's really exploded. Probably most notable was the filing of 10 class action suits in the Southern District of New York on one day back in April. So I'm going to ask Kristen first. Has the Blockchain Association participated in any way in private litigation so far? We know they filed an amicus brief in Telegram and Kick. What are we going to see from the Blockchain Association in some of this private litigation?
So we haven't filed anything in private litigation yet, but depending on how things play out, we would definitely consider it. Our sort of threshold is, do we think a case will lead to setting some sort of policy? Because our mission is to change the policy in a favorable way. So yes, there are a couple cases out there that we've been sort of tracking, and if the timing's right, we will absolutely voice our opinion.
Okay. Nicole, thoughts on private litigation?
Yeah, so we've been facing some class actions, and we've been able to apply some interesting analysis to these private litigations. Namely, you can look pretty closely at the named plaintiffs, and you actually can look at their wallets, their activity. Did they actually experience any losses at all? Are they holding the tokens anymore? So there's different ways to get at the named plaintiffs. And then, unlike in securities litigation, where in the plaintiff's damages models, you have to use some assumed one trader, two trader model. You can use that same tool in the crypto world, but you don't have to. You have the luxury of actually being able to see the Genesis block, to see the transactions on the blockchain, and you can have a much more sophisticated discussion about what your potential losses are, or what your potential exposure is in any class action. And I think that can go a long way in moving these cases to get forward, and also can help the projects make educated decisions about whether to settle or carry forward with the litigation.
Okay. Let me get to a couple questions before we get to the end of our program. One question is, this is for Steve. Shockingly, everybody wants to know what Steve thinks. Steve, to what extent does the SEC apply the Securities Exchange Act of 34 to digital tokens that it requires to be registered? So for digital tokens that would be under the Securities Act, would have to file a registration statement. How does that apply? How does the 34 Act apply to that? And follow up, I guess, is must a class of tokens be registered? And is this really about the problem that cryptocurrencies pose to banks with disintermediation? So a lot of different concepts there, but do you have any thoughts?
Well, with regard to the question of the 34 Act, the several settlements that we've done for registration-only cases, starting with the Airfox and Paragon cases, also including Gladius, and several others more recently, have included registration of the class of securities under the Exchange Act, and the filings that go along with that, which we acknowledge that's a significant process, but it's an important requirement in addition to the registration or exemption of the initial offer or sale. So even though there may have been a violation of the 33 Act and Section 5 in terms of the offer and sale of the securities and the offering initially, in terms of getting the information out there and helping with the informational disadvantage, the registration of the class of securities is significant under the 34 Act. And so that's why that's been a part of those settlements. Now, again, like I said earlier, every case has unique facts and circumstances. And so, it probably isn't going to be the case that makes sense with regard to every token or every token at every point in that token's life cycle. It really depends on how was it used in the initial offering and in the set of agreements related to that. How is it being used today? Has it changed in character? And that's all part of the analysis, both originating from the Hinman speech as well as through the framework. And the references to Ethereum are referring largely to the way that Ether became used in later transactions, different from the initial uses. So it is a complex analysis, but there can be times, and there have been times in some of our settled cases where we think it makes sense to do registration and to file the registration statement.
One more question before we get to our kind of final lightning round here. This is a question for anybody on the panel. Maybe I'll take a first shot at it. Do utility tokens really have to have a secondary market, or can they be offered within the marketplace they serve? I think this is picking up on something that Kristen said. I think even offered within a marketplace they serve, there is a secondary market in one sense. And some projects do require, because they require proof of stake and they require a lot of holders to be part of the network to make it decentralized, and partly to make it decentralized, but to make a lot of these projects go, you've got to have an ability to get large amounts of tokens into the hands of lots of people all over the world, and that just necessarily requires a secondary marketplace. And Kristen, do you have any other thoughts?
Yeah, no, I think that's absolutely right. The secondary markets are key to having a decentralized network. I mean, if I go to Chuck E. Cheese today, I go to the counter, I give them some money, they give me some game tokens, I play some games, and at the end of the night, Chuck E. Cheese goes in and takes all the tokens out of the game and resells them the next day. But if there is no Chuck E. Cheese, if there's no entity, but I still want to play the games, I need to get them from the secondary market, right? Because you remember, the infrastructure isn't owned by any one particular person. So you have to have the secondary market in order for these projects to work.
Okay, last question to the panel. What do you think is going to be the next big crypto development or story in the next year? Nicole?
Sure. One thing I'm expecting to see a lot more of is crypto exchange type cases, and that's going to be more towards trading and manipulation. So we've seen lots of spoofing actions in futures and securities markets, right? And spoofing. So the government, the Department of Justice have a pretty they have a playbook down for spoofing. And so I don't see why they wouldn't try to also apply this to crypto exchanges, because they can use the same playbook and move forward. So I'm expecting some manipulation, spoofing, and some wash trading coming out of exchanges, not to mention all of these private class actions we've been talking about.
Steve, don't listen to that. Don't do it. Steve, do you have any thoughts on this last one?
Well, I think, our hope always is that we see fewer sort of bad players in the space. Unfortunately, while we talk a lot about the registration cases and the litigated cases, which are very significant this year, a lot of our cases are fraud cases, and tokens and ICOs became sort of the fraud du jour, unfortunately. And hopefully as investors are learning more and becoming aware that many of these are not legitimate projects, we will see a decrease in that part of the space. So that my hope ultimately, and I think our hope, is that there will be more projects that really tap into the promise of blockchain and the new technology, and hopefully doing it in a compliant way with the securities laws.
Kristen?
I think the biggest development, and this could either be good for the industry or potentially bad for the industry, is going to be what impact does the November election have on the makeup of the commission? Do we have a change in leadership? I think Hester's term is up in June, and does she decide to stick around, or does she? I think getting some different blood into the SEC could be both maybe a positive thing or a negative thing from the industry perspective. So we'll be watching that closely, because I think if we had the right combination of people who are interested in this, we might be able to get something that is a little bit more solid than this facts and circumstances analysis that we have to use today, because that does prove to be a barrier to getting these projects off the ground.
All roads lead to the November election. Very quickly, my prediction is, in one of these private cases, I think you're going to get a judge who writes a very thoughtful and persuasive opinion that finds that a particular project did not engage in an unregistered securities offering. And I think the judge is going to critique the broad SEC, or what I would say is overbroad SEC analysis that's been applied in Kick and Telegram. And I think we're going to get maybe the pendulum perhaps swinging back a little bit towards the middle. But we will see, and we'll talk about that next year at this time. Thanks.
Thank you, Mike.
Great panel. Thanks.
Thank you, Mike. Thanks to the whole panel. Terrific. Crypto, a topic that didn't even exist at this conference just a few years ago, and now is a hugely important and hugely interesting area. Thanks. So next up, 1010 is the Financial Disclosure and Accounting Fraud panel. We'll see you in just a few minutes. Thank you.